I have is Christopher Hillbornne versus Megan Darlington. This matter was last before the court. Well, actually, let's see, back on July 18th. The matter was continued to today's date with the expectation that there would be potentially new information and potentially a new child support worksheet. I also noted that Mr. Hillbornne had indicated that he might wish to contest other aspects of the case. Uh, I don't, and maybe it just hasn't caught up with the hard copy of the file. Ms. Hawks, is there any new child support worksheet in the case?
Your Honor, there is not. And I'm not for sure this child support worksheet got filed back when the motion was filed, but there was a child support worksheet circulated for $843 a month. That was prepared back in April of 2025.
I think I had seen one in the file that was fairly recent. Let me see if I can find that. You said that was filed in April?
It was prepared in April, but it does not look like it got filed with that motion back in May.
Okay, all right. So we're just here on the motion for support, and with the child support worksheet that would potentially be forthcoming, suggesting an $844 per month amount. Uh, do you have any particular position or prayer as to how I move forward today, Ms. Hawks?
Your Honor, I don't believe I've received any updated information from the parties since that July hearing as far as updated income information. So I have no reason to believe that that 843 child support worksheet is not appropriate at this. I mean, nothing that would counteract that.
All right. Mr. Hillbornne, what's your position on the moving forward of this case with that calculation of 800, I think you said $43 per month?
I would wish that a paternity test would be done, but I understand that won't ever happen. I've asked 11 times and it's been denied all the time. So I guess I have no other choice but to accept the amount.
Miss Darlington, is there anything that you would like to say?
No, Your Honor. I'm on board with you and Ms. Hawks.
Well, and I haven't made a decision yet. I was just trying to explain to Mr. Hillbornne what Ms. Hawks was suggesting her position was. I know we're running a smidge behind, but I'm going to go off camera and off mic for a second. I just want to review a couple of things in the file. I was particularly interested that there were permanent parenting decisions made, and so child support agreed to back in 2021. Ms. Hawks, on the chance that the child support worksheet didn't get filed, can you just explain in kind of an overview how the $844 number is arrived at?
Yes, Your Honor. So we have father's gross domestic income at $6,496 a month. That was we got that number by using the information that was provided on his employer verification letter for a job that says he's been there since 2013, as well as some VA disability was included in that. We have mother's domestic gross income at $3,813. This gives a combined domestic gross income for both parties of $10,309. Father lives in the state of Kansas, but we have mother residing in Colorado. So she receives an interstate paid differential adjustment of $429. This brings father's child support income down to $6,496 and mother's to $3,384 for a combined total of $9,880. We have one child in the 6 to 11 age bracket for a guideline amount of $1,522. Father's responsible for 65.7% of that. Mother's responsible for 34.3% of that. We have that mother has work-related childcare costs for the summer, which average out to about $85 a month. For child support purposes, that was the guidelines kind of reduced that down to $64. Father's share of that's $42, mother's share of that's $22. So this brings father's basic parental child support obligation down to $1,042 a month and mother's to $480. However, mother claims the child for taxes each year and father receives an income tax consideration adjustment of $199 a month, bringing his adjusted subtotal down to $843 and mother's up to $679. That $843 survives the ability to pay poverty guideline calculator. So there's a bottom line child support payable by father of $843 a month.
All right. Do either of you have anything you'd like to say about the calculation, Mr. Hillbornne or Miss Darlington? Oh, I think you might be muted, sir.
I didn't think disability was allowed to be figured into that.
Well, and I do know that some payments are excluded. Ms. Hawks, do you have any additional information as to specifically what those are or how you included them in the calculation?
Your Honor, the guidelines only exclude supplemental Social Security income from being included in the guidelines. Social Security disability income and VA disability are allowed to be included as gross domestic income per the Kansas child support guidelines.
Okay, thank you. Any further questions, Mr. Hillbornne or Miss Darlington?
Not for me.
All right. If there is nothing further, I am going to modify support to the requested $843 per month. Ms. Hawks, what date are you suggesting as an effective date?
Your Honor, we filed this motion in May, so I would request this be effective June 1st.
Okay, that will be the order of the court, and I suppose that will create at least a little arrearage at the outset. And my intention, given that this is a fairly meaningful increase, is to just order or authorize an income withholding order in the amount of $843 for current support and $20 a month towards any arrearage balance until paid.
Thank you, Your Honor. And father is current on his obligation right now, so it would only be the arrears created by this order.
Okay. All right.
So,
well, thank you.
Test?
What's that, sir?
I can never get a paternity test.
Well, it would seem to me, and I would let you hire an attorney or ask those questions if you would like, but it looks like you had agreed to the support and the acknowledgement that you were a parent, at least on the face of the document back in 2021 at least. And so if you have other concerns with respect to that, you'll have to either do your research or hire counsel, but I'm not seeing anything in the file that would lead me to conclude that that's a question at this point.
It has to be appointed by a judge, and this is the 12th time I've asked. I'm just saying.
Well, and I just am reading from the journal entry, and let me try to find this language here. So this is from document styled agreed journal entry of judgment and decree of divorce. permanent parenting plan.
Yeah. Your Honor, if I
Yes,
may,
sir.
I'm sorry to interrupt, but I am apparently on the wrong meeting. My name
What's
is
your name,
Marlon,
sir?
Marlon Tilcock.
You're in the right meeting. We have one other case we're finishing up here, and then I'll call your case
Oh,
next.
I'm so sorry. I'm sorry, Your
That's
Honor.
okay. So it basically is saying that you had no desire to be involved with the minor child, that you would have no parenting time as a consequence, and then there was agreement concerning the amount of support to be paid. So I don't see uh, a timely request at this point for paternity testing. But if you have some theory of the case that is escaping me at this point, you're welcome to proceed along those lines, sir. Did you have anything further, Mr. Hillbornne?
No, I have to accept it. I understand.
Okay.
I understand. It's whoever just shows up is the one that has to pay. I got it.
Well, I want to say a couple things about that. I appreciate that these matters are challenging for everybody concerned, myself included. And I understand how, if you're feeling you've raised this specter 11 times previously and again here today, you may be left feeling like people aren't hearing you as much as they should.
No,
And I feel like I'm trying to put myself a little bit in your shoes. I think the challenge I have is with the years that have gone by and the previous orders in the case. I'm not seeing a clear way where that question could be raised at this point, but I am far from being perfect. And so if there is some methodology that you think makes sense, you're welcome to proceed in whatever ways you think are best. But for whatever faults I have, and they're probably innumerable, but I don't feel like it's just a question of making a decision haphazardly because one party was there first or made some kind of allegation and ergo there's nothing else to be considered. I've tried pretty hard to hear what you're saying and look in the file and consider your heart and your concerns, but I just don't see at this snapshot in time, with so many years gone by, that we're doing anything other than just considering modification of the support. And I think what's been explained, and I asked counsel to explain that on the record so that you would be able to hear that too. It seems that the calculation is in order, and so I am going to make that order. And for whatever it's worth, I tried also to put myself in your shoes a little bit, knowing that that's a relatively bigger number by way of having the arrearage, such as it might be. I know it'll only be hundreds of dollars, but I tried to make it a little easier for you by not ordering $100 or $100+ a month towards that
no, I
arrearage
mean,
as it's caught up. So, but in any event, I don't expect to necessarily.
no, it's fine, Your Honor. I understand you're just going to double it over a child that is not mine, but whatever. Do as you wish.
Well, I will stand by the orders I have made, and at the same time, like I said, I feel very viscerally some of the things that you're explaining from your heart, and I'm not unmindful of those, sir. All right, if there's nothing further, we can be in recess on the Hillbornne and Darlington case. I actually, Miss Hawks, was there anything I had forgotten from DCF's perspective?
Nothing further from the court, Your Honor.
All right. On the record in the matter of the marriage of Tia McBride and Kyle Keplinger, the DCF appears by and through Miss Hawks. Miss McBride appears in person and pro se. There are no other appearances. I believe this matter was last before the court on August 1 of this year. However, I think it was noted at that time that one of the Zoom links was incorrect and the matter was continued to today's date so that the parties could be sent additional notice. Ms. Hawks, can you summarize for the court your current position and prayer on this case?
Yes, Your Honor. Yes, Your Honor. Sounded like I had an echo. I apologize. So the parties had previously had an order for Mr. Keplinger to pay $1,652 a month. However, it looks like they entered into an agreed parenting plan at the beginning of this year that was signed by Judge Hart in February that modified child support down to $1,200 a month. However, during that time, father had requested DCF review the case for modification. And so we were kind of in the process while all of that was happening. And based on our review, we prepared a child support worksheet that shows that we believe that the guideline amount shows that Mr. Keplinger should be paying $750 a month. I will note that that agreed parenting plan that the parties entered into. My best guess is that $1,200 is a number that they came to together as an agreement, because I do not see a child support worksheet that supports that number. And so the state filed a motion for modification of child support on March 31st. Like you had already stated, we had a hearing previously, but the notice had wrong Zoom information. So at this time, DCF's requesting to modify the child support to $750 a month. That would be effective back to April 1st, Your Honor.
All right. Ms. McBride, do you have anything you would like to say about that proposed modification?
I guess I'm a little bit confused about that because the 1,200 came from, he joined the military, so he had all of that figured out by the military's child support people or whoever does that. And that's what the form should have been sent to you guys, saying that the military has all these like rules, regulations, whatever. It's a modified thing, and it was 1,200. So I'm confused of why it's not 1,200 if that's what I signed.
Okay. All right. Give me a moment to review the file. I don't remember having seen anything from the military, but let me double check and make sure I didn't miss anything, and I'll come back into the meeting shortly. Thank you. I think that there is, from the court's perspective, at least a couple of important considerations. One, I do understand that those who serve our nation in the military have responsibilities that are markedly different from those of us that are not in such service. And I want to be sensitive that there might be some more information that would be relevant to any final decision in this case. But I also think it's noteworthy that there was an agreement which was signed in February of 2025, where the parties agreed that the $1,200 per month support amount was the correct amount, and the domestic relations affidavit that was relied on in this case as far as consideration of any change of circumstances was actually dated, it appears, December 9 of 2024. Now, I don't know if that's a file date, a date that it was received by DCF on, whether that was a date that was indicating when it was sent out, but it looks like it was at least signed on November 23 of 2024. So it does not appear from the court's perspective at this snapshot in time with the information currently available that there has been a material change of circumstances since the earlier agreed support order was put in place. And so I'm inclined to leave the order as it is at this point in time. However, again, wanting to be sensitive to military service members, I can do one of two things, Ms. Hawks, if it would be your preference to continue this to a date certain so that you could see if another domestic relations affidavit was something that the parties would want to have the court consider, or we can just basically leave the support and other orders in place pending any follow-on domestic relations affidavit or any other requests that the parties may make. Do you have a preference as to which way we should go?
Your Honor, well, I guess first I'd like to confirm if Mr. Keplinger is still an active member in the military, because it appears in our system that we tried to send something to DFAS and DFAS responded with that individual is not known.
Okay.
Is-
Okay.
No, for a fact, I don't know what happened because I have very little communication, but he was supposed to start basic in March of this year. That's whenever we signed all that, sometime around that time, we signed all that paperwork for like child support and all that kind of stuff. And then it got pushed back because he had a civil lawsuit on him, that so he couldn't go to basic because he was getting sued by someone else. And then so he just now went into basic, I think in what is it, September, the middle of August, I think. So he's in basic right now. So as far as I know, he's in basic right now.
Do you have any idea, and I don't know that you should or would, but how long that basic training component
Yeah,
is supposed to
I
last?
do have a document that was sent over to me that kind of states like the dates, I guess, of the basic. I believe it was, I'll have to look for sure, but I'm pretty sure it was like a 66 day or something like that, around there.
Okay.
Train in South Carolina, or North Carolina, one of those two right now.
Okay. All right. Well, with that additional information, Ms. Hawks, do you prefer we set this over to a date certain or just take it off docket pending the submission of a new DRA?
Your Honor, my issue is I'm pretty positive I know what Ms. McBride is talking about with that Army regulation. I'm pretty sure it's 608-99, which is what the Army uses. They kind of have their own schedule when they are determining what a service member is supposed to pay prior to court involvement. My issue with that is DCF has an assignment of rights, and our policy dictates that it has to be by the Kansas child support guidelines, not, which would mean not Army regulation. And once the court case is going, I believe that trumps the Army regulation, the court order. So I would prefer at this time to, I guess, maybe push it out after the first of the year so I can keep track of this. I don't want it to get lost, but either way, DCF policy is going to mandate that we have to review this for a modification because the current order does not conform with Kansas child support guidelines.
Well, and I think I wholly understand and agree with that position. I just do think we ought to have a DRA that's on the right side of the enlistment and on the right side of the agreement that was previously signed off on by both parties. So I think that if we're anticipating perhaps circulating a new DRA, I don't know that I have, honestly, and I should have, and it's my shortcoming that I don't have, but I don't have a 2026 calendar. Miss Jackie, I don't even know if we've set any dates. It looks like the third. Well, no.
I believe it'd be like the 16th, 2nd or 16th.
You want to just set it for the 16th of January, then 2026 for further review?
Yes, Your Honor. And in the meantime, if we decide to withdraw the motion and take that off hearing and kind of restart over, I will let Ms. McBride know. But yeah, right now I would say January 16th to see if we can get updated information. So
Okay, so
Okay,
what
well, that sounds good.
do you mean for any kind of payments for me? Because I literally have gotten like nothing in, I mean, in 3 years. So I'm just,
so
Well, and
oh.
go ahead.
So it does look like back in May when we sent a request to DFAS, that came back that he was not known, but if he is in basic now, we can send out another request and see if we can get child support payments going now that he's back in basic.
okay, so none of that stuff has to wait until that first of the year that you guys are talking about, if he's actually active, and then I could actually start getting some payments, correct? Hopefully.
Yes.
Okay.
That should indeed be the case. And basically, like I told you at the front end after reviewing the case, I'm just acknowledging that there's a high value in the agreement that had been struck, but there's also a value in the concerns raised by Ms. Hawks. And I also think it's important that we take into account that maybe the reason Mr. Keplinger isn't present today and able to shed additional light is because he's preparing to defend our nation through the basic training course he's on right now. So I want to make sure that we have a chance. And like I said, I think that if we're talking about changes of circumstances, it might be helpful to know exactly what those will look like after he's passed basic and maybe a little further along in the process.
Thank you, Your Honor.
So thank you. If there's nothing further, we'll continue this to January 16, 2025 at 9 o'clock in the morning, and we'll look forward to seeing each and all at that time. Thank you, Ms. McBride.
Thank you.
Thank you, Your Honor.
Thank you. This matter was before the court back on the 1st of August. At that time, the court made a temporary child support order in the amount of $1,004 and continued the matter to today's date. And it looked like there was some concern that maybe you didn't have the most current link for Zoom purposes. So the matter was set to today's date and new information was sent to you. And apparently you have received that and are now in the meeting. Ms. Hawks, from DCF's perspective, do you have a current position or prayer in this matter?
Yes, Your Honor. So at this time, well, I'll back up just a little bit. Father was ordered to pay $1,796 a month. We filed a motion to modify child support and a child support worksheet that shows a guideline amount of $1,004 a month. Back in August, I believe this was set for hearing. And apologize, I looked at the wrong thing. Yes, back in August, it was set for hearing, and Mr. Johnson, he appeared even though that we had sent out the wrong Zoom link, but Ms. Moore had not. So the court entered a temporary order and then continued it today. So it would still be the state's request for that $104 a month, with that to be effective April 1st of 2025, Your Honor.
Well, Ms. Moore, is there anything you'd like to say about that, ma'am?
I just want to make sure that the back child support gets paid, but outside of that, I'm fine with changing it. If he can't pay
Okay.
it, so it needs to be modified.
All right. Do you happen to have, Ms. Hawks, easy access to any arrearage balance in the case?
Your Honor, I'm showing right now that there's an arrears of $1,935.25. However, when we backdate this to April, it's very likely that that arrearage is significantly impacted.
Mm-hmm. Do you want to speak to that question, Ms. Moore? And I think what she's saying is if the previous order was for, I think it was $1,700 a month, and if this has been pending since April and if the court indeed, or since March, if the court indeed ordered it effective April 1, which is the statutory bias, that would mean that for those months between April and September, there would have been an approximate $700 per month overpayment. So it would, yes, the $1,000 arrearage would be paid, but it might also be the case that there would not be any arrearage showing beyond that, and in fact, it would look like an overpayment for the purposes of the payments that are actually due prospectively.
So once this is done and finalized, then it'll be as effective in April instead of September.
That's what's being requested, and that's pretty typical. It normally would be the case that it's the first day of the month after the motion was filed, and the motion, I'm assuming, was filed in March. Let me just double check that. Do you happen to have the date handy, Ms. Hawks, of the?
Yes, Your Honor, it's March 31st.
Okay. Did you have anything more you would like to say, Ms. Moore?
No, that just changes things for payment wise for the kids and stuff. So I just have to figure that out.
I won't take long. I know we have several people on the call, but I just want to review the file very quickly before I make my order. All right, we're back on the record in Johnson versus Johnson now. Moore. I reviewed the file, and the motion was indeed filed on March 31. It references an attached child support worksheet, which was filed actually in April. And I think in the circumstances, I am going to modify the support to the requested, and I think calculated $1,004 per month. But I'm going to make that effective on May 1, given the date of the worksheet filing. And if you could please prepare orders along those lines, Ms. Hawks, I would appreciate it.
Your Honor.
Yes, ma'am.
So that is going to create an overpayment, and to avoid a situation where Mr. Johnson's paying in and DCF just sends all of that money back to Mr. Johnson until the overpayment is resolved, it may be more beneficial to issue the income withholding order at a slightly lower rate until that overpayment is resolved. So I would propose maybe $850 or $900 income withholding order until that overpayment is resolved. That way, Ms.
Okay.
Moore's not going, 8 to 12 weeks without any child support.
That would be great.
Right. Okay. Well, I will do as has been requested and have a new income withholding order in the amount of $900 per month until the overpayment is offset. And if you could please, and thank you for that suggestion, Ms. Hawks, I think that is an important one, and I think it makes a lot of sense. So if you could please draft both the order modifying support and the new income withholding order, I would appreciate it.
Yes, Your Honor.
All right, thank you. Thank you, Ms. Moore.
They're not going to take as much for my child support for that time period that the overage is resolved, correct?
That's correct. Yes, sir, that is correct.
Okay. All right.
All
That's
right,
it.
thank you. Thank you
Thank
very
you.
much. We are on the record in the state of Kansas on behalf of the Secretary for the Department for Children and Families et al. Versus William Hutchkins.
So the state filed a petition for parentage in October of 2024, listing 2 children, KH, year of birth 2009, and DRH, year of birth 2011. Mr. Hutchkins is listed on the I apologize. I believe he's listed on the birth certificate for DRH, year of birth 2011, but is not listed on the birth certificate for KH, year of birth 2009. Mr. Hutchins was served in May and has filed an answer. The state filed a motion. Apologize, let me bring that up. Amended motion for judgment for paternity. It was brought to my attention after some further research that there was a Sedgwick County case. It ultimately got dismissed, but within that case, Mr. Hutchinson filed to establish paternity for both children. Then they did genetic testing and found that he was not, when I should back up, and in that petition, he alleged himself to be a presumed father of KH. Then they did genetic testing. It showed he was not the biological father of KH, but him and Miss Cubbage ended up entering into a memorandum of agreement to parent both children. And so at this time, I believe there is a presumption that Mr. Hutchinson is the father of KH. And I don't believe genetic testing is appropriate at this time. And that if Mr. Hutchins is contesting that, I think we need a guardian ad litem.
Mr. Kidwell, what's your client's perspective on this?
Your Honor, may I ask my client if he can speak?
Sure. And do you want to speak with him in a breakout room privately, or are you asking him
Yeah,
to
could
speak to the
I
court?
have a few minutes? Just
Yes,
maybe
yes.
5 minutes?
Take however much time you need. And when you come back in, if I'm distracted, let me know you're back in the meeting, okay?
All right, thank you.
All right, thank you. This matter comes on a motion seeking modification of support. I see that there were a couple of different child support worksheets submitted. One a bit lower than the currently ordered $710 support at $544. The other one slightly more than the current support at $737. Ms. Hawks, what is your current position and prayer on this case?
Your Honor, so the state reviewed this for modification as father was at father's request, because he does have another child. So I reviewed the file and it looks like the last time they modified child support, the court denied to apply the multifamily adjustment for one additional child because Mr. Farthing was living in the Oxford house. I don't know where he's residing at this time, so he did ask for us to review. I've filed 2 child support worksheets, one with Mr. Farthing receiving the multifamily adjustment for one child, which would show a guideline amount of $544 a month. The second one without, which would show a guideline amount of $737. So I will let the court maybe talk to Mr. Farthing about where he's residing and if he does have a biological minor child residing with him on a full-time basis before we proceed.
All right, and Mr. Farthing, can you address those questions, sir?
Yes, Your Honor. Give me 1 second here. The questions were, are the minor child residing with me full-time? Was that one of the questions, correct?
Yes, yes. Where are you living and do you have a minor child residing with you?
I have bought a 4-bedroom house the last time we have talked. He is with me full-time. He's actually outside right now playing while I'm in here dealing with this. All I'm seeking is dual family. I've got 2 beautiful children that I'm trying to take care of. One is very unfortunate what happened between Brandy and I regret that. But yet again, I also have another child with Michelle that needs part of my income as well. And all I'm seeking is dual family. Like, that's all I want to focus on, is getting dual family. I've been in my house now 7 months. Now 7 months, I do believe, and I pay all bills. Michelle does not work. Not that that matters or anything like that. I just want the courts to be fair with me, as long as with Brandy as well. But I really would like dual family because we are wanting another child.
Okay. Ms. Sims, is there anything you would like to say at this time?
My only thing is that I take care of Bryson all by myself. I'm single. I have one income. I do everything. Sports, all medical bills. I pay for all medical bills. He's about to be getting braces. I'm going to be paying for that. I don't know if that factors into anything, but I pay for childcare. I pay for a lot. And I understand them lowering it some for him. I'm not against that. I understand he has another child. The older Bryson gets, the more expensive he gets. It's crazy. But I mean, I'm not against them lowering it for him.
Well, and just the child's change of ages at certain points might augur for prospective motions to modify. But I think that the guidelines contemplate that the children will get more expensive as they get older. And those are certainly things that are also grist for the discussion mill and potential motions being filed in the case. And certainly if you have those sorts of concerns, you're welcome to reach out to DCF as well in future. Ms. Hawks, was there anything more that you wanted to say, having heard from both Mr. Farthing and Ms. Sims?
Your Honor, just that if the court chooses not to apply the multifamily adjustment, the child support worksheet shows a guideline amount of $737. That's an increase to Mr. Farthing's child support order, but also it does not meet the 10%, and so it would not meet material change in circumstance. So if you don't apply the the multifamily adjustment, I would withdraw my motion to leave it at the 710. If you do apply that, then it would go down to the 544. And then just kind of to preempt anything in the future that Mr. Farthing said they were possibly going to have another child, that the guidelines, don't automatically grant him additional adjustments for more children he has. That is a court discretion, but it's not a guarantee in the guidelines to lower that child support. So.
Okay. Well, I think that this is a challenging situation in that I think both Mr. Farthing and Ms. Sims are experiencing what it seems we all experience, and that is that there's never enough resources when it comes to the care of the children that we love. And it seems that the child involved in this particular matter is fortunate to have parents that care about them very much and are striving to do the very best they can by them. I think that from the court's perspective, and even in Ms. Sims' acknowledgement, there are, I think, important reasons to make the multifamily adjustment, and I am going to order support in the amount of $544 per month. I do want to reiterate that there may come a time when modification should be considered, and it could be the case that the modification would go in the other direction at that time. But at least at this snapshot in time, it seems appropriate to make the adjustment. I also just want to say I don't know many of the details, and I'm not trying to pry, but I would dare say that Mr. Farthing, going as you have done from an Oxford house to home ownership, and in such a short period of time, would seem to indicate a lot of effort on your part to try to learn what needed learning and to adjust what needed adjusting. And I think that's noteworthy. And I do think that from the court's perspective, the modification should be effective September 1 of 2025. And Ms. Hawks, if you could make an adjustment along, or rather an order along those lines. And do you know, will that result in any overpayment?
Your Honor, I don't believe it'll result in an overpayment. He owes us a slight amount of arrears. But once this is modified, it looks like he'll still owe about $175, give or take a little bit. I'm not 100% on the math right now.
Okay.
So I don't think it will result in an overpayment at all. I'm fine if we
Okay.
just issue the income withholding order for $544 a month current only. And then if it looks like there is still some arrears, we can always add $10 or $15 to that later on.
All right. I think that makes sense, and that will be the order of the court. And if there's nothing further, go ahead.
Sorry, I just had one question. As
Yes,
far as
ma'am.
like the medical bills and stuff that he's supposed to pay half of, it said it on the order. How do we go about that? Because he's never paid a medical bill.
Well, if that was the original order, that should be something that would be taken care of. And I guess I might defer to you, Ms. Hawks. I mean, I don't know that that's directly something that would involve your agency, but I want to make certain before I opine further.
Your Honor, so DCF will always help collect on medical judgments. However, we do not file for the party requesting that judgment. So I was pulling it up, trying to look. It looks like Mr. Farthing would be responsible for 52.1% of all uninsured medical expenses. And Ms. Sims is welcome to file, any of her own pleadings to try and create a judgment. If the court orders a judgment, DCF absolutely would help collect on that, but we don't assist in getting a final order on that judgment.
Right. And I suspect Ms. Sims, and I don't know if the order speaks to this directly, but I suppose making Mr. Farthing aware of any expense that you've incurred in which you believe he should be contributing to would be a first step to try to see if those payments would be forthcoming. And then, as has been pointed out, if that is not the case, you can make what determinations you think are appropriate concerning any filings with the court.
Okay, no worries. I'll pay him.
Okay. Well, if there's nothing further, then we'll be in recess. And Mr. Farthing and Ms. Sims, you're free to log out of the meeting. Thank you.
Okay, thank you.
In the matter of the marriage of Crystal Lyn Marino and Gavin Marino, the case number is Butler County 21 DM 569. The DCF appears by and through Ms. Hawks. Mr. Marino appears in person and pro se. This matter was last before the court on July 18th, at which time the parties appeared as they do again today. The warrant, which had been earlier issued, was set aside, and it was noted that Mr. Marino was currently at that point employed at Church's Chicken. I believe IWO was authorized and the matter was continued to today's date. Ms. Hawks, do you have any update from DCF's perspective?
Your Honor, I don't. We have not received any payments via the income withholding order, so I guess I'd like to know if Mr. Marino is still working at Church's Chicken.
All right, Mr. Marino, can you update us on your situation, sir?
Yeah, I was working there, and then the infection that I was dealing with that was in my bone on my spine wasn't gone. So I've actually been back in the hospital, and I'm supposed to be out the 26th of this month.
Okay. Do you have any idea whether or not the Church's Chicken job would still be available for you at that time, or will you be basically starting afresh in terms of any job
Yeah,
search?
I have to start over again because like I was trying to go to work and then I couldn't make it into work because I could barely walk. So they just went ahead and let me go. And then that's when I came back to the hospital and I've been here ever since for over almost 2 months now.
Okay. Ms. Hawks, in those circumstances, do you have anything to add or any requests of the court?
Just that we continue this out, Your Honor, until Mr. Marino is out of the hospital and working.
Okay. And you say you're poised to leave the hospital on the 26th of this month?
Yes, sir. Yeah, I had my MRI done last Tuesday and it showed everything looked good. The abscess that was on my spine is gone now, and they was able to stop the infection from spreading anymore in my bone. So yeah, I'll get out the 26th once my antibiotics are done.
Well, I'm sorry you've had to contend with all of that, but I'm happy for you that you have a good prognosis, and it sounds like you'll be able to apply your energies towards getting work and getting on track in this case after the 26th. Ms. Hawks, I was thinking that we have an October 3rd date, but that's so close in time to that September 26th release. I was thinking about using either October 17 or November 7 even as a date for further hearing. Do you have a preference?
Your Honor, I think maybe the November 7th to make sure Mr. Marino has enough time to find employment and start getting paychecks. That way, when we issue that income withholding order, it can start paying.
And
That makes sense from your perspective, Mr. Marino?
yes, sir. And I have been actively applying while I've been in here, and I've had several on the phone interviews. So I'm trying to do my best. As soon as I get out, I can hit the ground running again, so I can make sure I get this taken care of.
Okay. If it transpires that you do find work fairly soon, and if you're in some probationary period with work that will continue through or past November the 7th, please advise DCF that you have found employment and they might be able to get that income withholding order issued and perhaps save you from having to come in on a day when it might be more expedient from your boss's perspective that you just apply your energies in the direction of your job. Okay.
Okay.
All right. So I will continue this to November 7, 2025 at 9 o'clock, and we'll wish you good luck and look forward to seeing you then. And again, I'm happy for your positive prognosis. It sounds like you've really been through a lot, and it sounds like your doctors have done a really great job for you.
Hey, thank you. I really appreciate that.
Thank you. Have a good day.
Thanks, you too.